I had filed a case, and Judge Alan B. Haber, who was in Van Nuys, now in Santa Monica, he was the judge on the case. The other side defaulted. We're talking about $13,620,000. They defaulted on it. You know what default is? What's a default? I realize you got to be really basic. And so anyway, default is where they don't show up. And Judge Alan Haber was up there incoherent in his conversation. He says, I don't know why we're talking about a big major case here, and I have to tell you that my antlers are up on this one. You know, couldn't make a complete sentence to come to a period. It was all dashes and disjointed. Well, he wound up taking under submission, which he can do, my evidence. And under the Code of Civil Procedure 585B, which is the default statute, it talks about, it says that the judge shall hear the evidence and shall render judgment in plaintiff's favor in such amount as is deemed equitable by the evidence. He has to render a decision, at least something. I'm suing for $13 million. He has to enter a judgment. He has 90 days under the Constitution of the state of California to render a judgment. If he doesn't, he forfeits his pay according to law. And of course, every judge has to sign they have no cases pending and undetermined in excess of 90 days in order to receive their salary. He has to sign that every month. Well, Judge Alan Haber made his decision. You know what his decision was? He made his decision not to decide. I would say we're probably about 7 to 8 years that my decision is set there without a decision. And of course, you can't appeal a non-decision. You can't go up to the Court of Appeals and say, I'm here to appeal below. He said, well, what's the decision? Well, that's the problem. We don't have a decision. Well, you can't appeal until the decision. Well, that's what I'm here for. So I had to take a petition for a writ of mandate, which means that if you have no other means by which you can take an appeal, then you have the appellate court command him to enter a decision so that I can take an appeal up to the appellate court. Their response was denied. Well, you can't deny it. The statute sets forth that it's mandatory. You have to do it when there's no other avenue by law. You can't appeal a non-decision. They just said denied. So I went up to the state Supreme Court and I said the appellate court had no discretion to deny something that has no possibility of any other remedy. Well, you know what their answer was? Denied. I took it to the United States Supreme Court. We don't want to hear this. Denied. $300. Thank you. I went to the federal court and sued because they said I have no remedy in the state court. Well, they just said, well, he's covered by immunity and he can't sue him. You know? So I go up to the Ninth Circuit Court of Appeals. And what they said was, well, you just don't like his decision. I said to the judges, I will give each of you $5,000 apiece if you will produce the decision that I don't like and show me a copy of it. I said, I'm here because there is no decision. But this is to give you an idea. When you have law that says the judge shall hear the evidence and shall render judgment in plaintiff's favor. I don't know about you, but I've always learned that shall was a mandatory word. It didn't say may or it's recommended.